Welcome to Tennessee Court Talk. I'm your host, Nick Morgan. Today we're talking about the Tennessee Court of Criminal Appeals. The court was created by the Tennessee legislature back in 1967, and it plays a unique role in our judicial system. Unlike trial courts, you won't find witnesses, juries, or live testimony here. Instead, cases are decided based on written briefs and oral arguments from attorneys. In 1996, the Tennessee General Assembly expanded the court from 9 judges to 12 to help manage a growing caseload. Today, those 12 judges represent all 3 grand divisions of the state. On this episode, we're taking a closer look at the court's history, its background, and how it really works behind the scenes. I'm joined by Judge Robert Wedemeyer, Judge Ross Dyer, Judge Camille McMullen, and Judge Jill Ayers. Judges, welcome to Tennessee Court Talk.
Thank you for having us.
All right, first we're going to get into why the court exists and how it developed. For listeners who may not know, why does Tennessee have a separate Court of Criminal Appeals, and what problem was it created to solve?
We have a Court of Criminal Appeals and a Court of Appeals. Obviously, the Court of Criminal Appeals handles all the direct appeals and post-convictions and things like that. And our cases, we have 3 divisions: Eastern Tennessee, Middle Tennessee, West Tennessee, 4 judges serving in each of those divisions. We sit in panels of 3, and almost every criminal case in the state, if someone is convicted of a crime, they have the right to at least one appeal when it comes to our court. Back in the early 60s, a lot of more constitutional rights were being recognized, and therefore the appeal claims became a lot more numerous. And so to deal with those, the Court of Criminal Appeals was created. And I'll yield to my colleagues on the
I'll just add to that. We were created, from my understanding, primarily to alleviate a lot of the caseload from the Supreme Court of the criminal cases that were being handled. When the CCA was created, there were initially 3 judges. And again, due to the enormous criminal caseload, the CCA was expanded, I think, to 6 or 7. And so we continue to expand based on the need. And again, that was because it began with all of the newly created constitutional rights that were being recognized by the United States Supreme Court.
Yeah. And matter of fact, when the U.S. Supreme Court in the 60s started expanding protections for criminal defendants, they were all filing in district courts. And so the U.S. Attorney's Office said, hey, states, you better figure this out or we're going to just start dismissing cases. And our Supreme Court heard all the criminal cases plus whatever else they were hearing, and they created the Court of Criminal Appeals. And within a year, they expanded it to 5 or 6 because the first 3 were already so overwhelmed. So that's kind of how we came into being.
Yeah, I think it's interesting that the criminal cases at that point went directly to the Supreme Court and not to the Court of Appeals. So I think the Supreme Court was just overwhelmed as well.
And just, you think about that. I mean, I haven't read this anywhere, but I'm assuming that they were still just, our Supreme Court was made up of 5 members.
Yep.
Can you imagine handling the number of cases with just 5 members? I mean, we have a challenge before us with 12. So I can only imagine how the cases were handled or managed at that time.
Yeah. And not to include their civil cases they were taking. And
absolutely.
The court has grown significantly over time. What has remained consistent about the court's mission since its creation, even as the law or even as Tennessee has evolved?
My response to that is what has remained consistent is we are an error-correcting court in that we review what happened at a trial, a criminal trial. We review what alleged errors occurred. If they are serious errors, we correct them by giving someone a new trial or what other relief. They are harmless errors. We will affirm what the trial judge has done in the case. But consistently, our job is to review to be sure both sides received a fair trial. And if not, we can correct it. So that to me, that's the consistent thing. That's no matter how many cases we have, no matter how many judges, the growth, it's pretty much always been let's achieve fairness and be sure that all the constitutional rights of every citizen are protected.
And I think just to explain to lay people who might be listening to the podcast, the difference between what we do as an appellate court and what maybe the Supreme Court does as an appellate court. The Supreme Court's concern or part of their mission is policymaking and policy driven. And so we don't do that. Our challenge is just simply to apply the law as we see it. A lot of people compare it to referees calling balls and strikes. We're not engaged in policy making at all. And also I'll say this, one of the things that's unique about the Court of Criminal Appeals is, we travel across the state. Everybody sits in one of each of the three grand divisions, Jackson, Nashville, or Knoxville. So the lawyers get a chance to interact with each of the judges on the court.
The fact that we travel and we mix with one another as far as panels are concerned, we try to keep consistent. We try to have the court be consistent on its positions to allow the lawyers to understand, like, here's what the law is. We're not trying to issue 17 different opinions that say 17 different things. We've really strived very hard to be consistent as a court as to what we think or how the law should be interpreted or followed.
And as probably the newest person on the court from this group of folks, when did that start? I mean, has our court always traveled and mixed up the dockets from the very beginning?
It actually goes back to when Judge Daughtry was on the court. I know that there was a push to get to know other members in the other grand divisions and see how the other members, handle their cases and caseloads and opinions, as well as interact, as what Judge Dyer was saying, interact with the lawyers in the other divisions. At least since 1975, our members travel to the other grand divisions.
And I really like that part of what we do, because again, it has, I think that's part of what makes our court so special, and the fact that we get along so well is that we all spend time with each other in different groups and in different locations. And I think that just makes us a stronger court. And as Judge Dyer said, more consistent.
When you look at the court's history, there are many trailblazers and judges who later rose to leadership roles. Who stands out? And what does that say about leadership in the court system?
Well, you just talked about we talked about the first one with Justice Martha Daughtry as the first woman appointed in 1975. That was a big deal at that time, I'm sure. It
was more than that in that, she didn't stop there, right? So to your question, part of your question was, they've gone on to other things. I mean, she clearly went on to much greater, higher ranks, whatever you want to say, than serving on our court.
Al Birch is one who went on to I think we've had maybe, I want to say 7 or 8 judges on this court go on to the Tennessee Supreme Court.
Yeah. For the listeners who don't know, we're talking about Martha Craig Daughtry, who was on this court for some time, then went on to be on the Tennessee Supreme Court, right? And then she went on to be on the Sixth Circuit. So just to track her path there. Then we're talking about Justice Adolphus Birch. He was the first African-American to be on this court and the Tennessee Supreme Court. And one thing that's notable about Justice Birch is that he was a judge at every level of the court system in the state of Tennessee. And I don't think that has ever been done before. And what I mean by that is to say he was a judge at the General Sessions level. He was a judge at the trial court level. He was a judge at the appellate court level or at our level. And he was a judge at the Tennessee Supreme Court. So that speaks volumes for the type of leadership that we have coming through the CCA.
When our current Chief Justice of the Supreme Court, Jeff Bivens, was one of our members as well. So, as was Roger Page.
And I would be remiss if I didn't also mention that one of those trailblazing judges is here with us today, as Judge Camille McMullen was the first African-American woman to serve on an appellate court in Tennessee when she was voted to the Court of Criminal Appeals in 2008 and served as its presiding judge from 2023 to 2025. Judge Wedemeyer, you've known Judge McMullen a long time. Would you like to say a few words?
She has been an outstanding person to work with. We are, in general, our court through the years has been very congenial. We get along great, most of us, most of the time. And I can say without hesitation that Camille and I have gotten along great, and she's gotten along great with the other members of the court. Whether it's just who has been on the court, or I like to think it's a lot to do with her leadership skills, we have had the most congenial, friendly, work together, get along, have fun at times group since Camille was the presiding judge in the last few years. She's spoken at the UT Law School commencement, and she just has represented our court in a lot of public ways in a very, very great way.
Judge McMullen?
I truly believe that the court system, it should be reflective of the community that it serves. And I am honored to serve on the court. I was honored to be appointed by Governor Bredesen back in 2008. I think we have, just as with women, we need to increase the amount of women that are on the court. We need to increase the amount of African Americans that are on the court. But I believe that, everyone is going to bring their own set of experiences to the bench. And I think the variety that we have on the court only enhances the product that we produce in terms of our opinions and in terms of how we interact with the public and how we interact with the lawyers. I just think that's important.
So let's move on to how the court actually works day to day, where we get into the meat and potatoes of the court. When a criminal appeal arrives at the Court of Criminal Appeals, what are the major steps from filing to a final decision in the simplest terms? Judge Dyer, you kick us off.
There's a lot of steps, but I think you can simplify it. So once the case is filed, and I'm just going to kind of throw in, the record is filed and the briefs are filed, then it's either set for argument or to be heard on brief, one of the two, depending on the request of the parties. Those cases, then Judge Wedemeyer, in his infinite wisdom, takes the cases in each grand divisions and sets a docket each month of X number of cases, depending on trying to keep the backlog, trying to not have a backlog, trying to get cases heard as soon as possible. And he assigns those cases to a docket. And then the three judges who have been assigned to that docket divvy those cases up. And if they're on brief, they handle them within their chambers and then circulate them to their colleagues. And if they're argument cases, you have argument and we discuss kind of what we think after argument's over with, and someone gets assigned a case and writes an opinion and you circulate it among your colleagues and you kind of go from there. That's really simple, I admit, but I think that just gives you kind of a very broad understanding. I think then everybody else can kind of fill in maybe the holes there a little bit.
Let me just take a step back, because when I talk to people, and I assume that there will be people who are non-lawyers that are listening to us during this podcast, what they need to understand is that we are an appellate court. Okay. And it's somewhat similar to, I like to, compare it to an Oreo cookie. The first tier of the court system are the trial courts. And that's where a lot of the nitty gritty happens. Those judges really are the workhorses of the judiciary. They interact with jurors. They interact with litigants. They interact with defendants. They interact with victims. They interact, and this is what they do on a daily basis. And whatever happens at that level, if a person is aggrieved by what that particular judge does, then they have the opportunity to appeal. And for the Court of Criminal Appeals, I like to say we're the good, sweet, sugary middle part of the Oreo cookie. Once they decide that something, they feel like something was done wrong at that first tier level, their lawyers can bring it up to us. And, I like to point out to the public that 99% of the time, that's where a criminal case is going to stop. Everyone has a right to appeal their case to us as the Court of Criminal Appeals. And we take those cases because we're constitutionally required to. So we listen to them. And as Judge Dyer explained, their lawyers write briefs. We read those briefs. And, depending on whether there's oral argument or not, we'll issue an opinion based on that. Now, once we issue that opinion, we have the Supreme Court, who is another layer of that Oreo cookie. And if the lawyers feel like we as a court, in our opinion, did something wrong or made an error, they have, the opportunity, because the Supreme Court doesn't necessarily have to take those cases, to appeal to the Supreme Court.
So what happens behind the scenes after an oral argument? Once the judges recess, the courtroom lights go off and the public leaves. Explain that process a little bit.
Following up on what Judge Dyer said, if it's oral argument, then we're going to sit back in chambers after the argument and discuss the case and get a general idea of where we think it's going to go and who's going to write it. I think one thing that has not been talked about yet is that there's a lot of record reviewing involved. We're going to read the briefs before argument and be prepared for that. If it's not oral argument, then we're just going to get the record and we're going to go through the record and look at everything in that record and the record includes transcripts from what Judge McMullen talked about happens at trial, all of the trial pleadings and the trial court's rulings. We're going to review all of that record, and then whoever is assigned to author that opinion is going to work with their staff in chambers to get a draft prepared. Once that's edited multiple times, then it's going to be circulated to the panel. We usually do that one judge at a time. Sometimes it's strategic about who you send it to first, depending on panels. I think we can all agree that may or may not be the case, but send it to one judge as the second reviewer. That judge reviews, weighs in, makes suggestions, says, yeah, I agree with this, or no, I don't. And I think we're going to talk about dissents later, so that can be covered. But assuming everyone agrees with just some edits, then the authoring judge is going to make those edits and get the final opinion filed with the clerk's office. And then from that point, that's where whoever loses the appeal decides if they want to file a Rule 11 to ask the Supreme Court to review what we've done.
I would just add the discussions within a judge's particular chambers and then also the circulating process can either be very simplistic or it can be a lot of emails and phone calls and things just to kind of can we get everybody on the same page, or is this something that, you missed? I think you need to add this because there's a new case out there that maybe you missed, or I don't read that case the exact same way. So, or it can be, hey, we all agree and it goes on. What you think is a case that should come out pretty quickly takes, a long time to get everybody on the same page to sign off on.
I think that's what makes good opinions with our court. I mean, I don't know how everybody feels. I'm generally unoffended by anybody's comments. I mean, I don't mind if somebody's going to even show me something nitpicky because I want what comes out with my name on it to be the best product it can be. I know that regardless of which panel I'm on, I've got some really smart, great judges here that are going to help me make sure this opinion is correct. And so whether, as Judge Dyer mentioned, it's somebody saying, hey, have you thought about this case? You might want to add it. Or maybe, hey, I don't read this case the same way. Let's talk about it. I think all of that is what helps make our opinions better.
Okay, so let's move on to dissents then. How does a dissent come to be, and how does it make it into the final opinion, etc.?
This goes into that strategy about where you're going to send your opinion first. I think Judge Ayers was saying that a little like jokingly, but in all seriousness, it matters. The second judge the reviewing judge has a big role in determining, how the opinion is going to go, whether they agree with the draft as it is circulated or not. So the second reviewing judge is very important, and their review will dictate, how the third reviewing judge will approach the case, knowing that, if they don't agree with the first two, they will be in the minority and have to work backwards to either convince the author to come their way if they disagree on a certain issue, or not. So
Yeah.
it's an interesting dynamic, but I will say, it's not difficult when you have a good relationship with your colleagues. Sometimes it's just a matter of picking up the phone and saying, hey, how strongly are you tied to X issue? Would you mind, adding, this or whatever? And sometimes it's a matter of saying, hey, is there any way we can come to a consensus on this? And if it's not, then, there's a draft sort of kind of, here are my thoughts. That's the way I approach it. Here are my thoughts. What do you think? Sort of kind of thing. And if there's a absolute, no, I'm not, feeling that, that's when, at least for me, I go into drafting a dissent or a, concurring opinion.
I agree with all of that. The one thing I would add to it is I think you don't see, one thing I think is really great about this court, I guess, is you don't see tons of dissents. Not because we're not independent thinkers, but because of the collegiality, so to speak, and the openness using, as Jill said a second ago, she wants people to even nitpick and get you to think. And I think we as a court are very good. No one gets really offended of, hey, look at this. And it's much easier to reach common ground. And which goes back to then therefore we're putting out consistent opinions and not a bunch of, 2-1 decisions with a dissent or a concurring opinion over here. We've reached common ground on what we believe the law for how a case should be resolved.
We really don't have very many dissents. And the reason, there are a couple reasons for that. The primary reason is, in my opinion, that the issues that come before this court are very, it's a lot of the same issues, and the law with regard to those issues is pretty much the same law. I mean, they're new laws are enacted, of course, we follow those, but the types of issues and the law we're dealing with are pretty set. And a lot of times it's just something that's, like I said, unless there is a serious error involved in the way the trial judge handled things, or the jury was misinstructed or something, the vast majority of our cases, we're going to affirm what happened at the trial level. And another factor there is an appellate court, it's not our job to substitute our judgment for what should have happened at the trial. We might have a case in front of us where a defendant was sent to prison, and the panel might think, gosh, if I were the trial judge there, I would have given that person probation. But as long as the trial judge followed the principles of sentencing, it's not our job to substitute our judgment for the trial judge. There aren't a lot of dissents on our court for that reason. Now, what these colleagues had pointed out is I totally agree with. If there is one, if we have a disagreement, we resolve it in a nice, healthy discussion.
And the only other thing that I'll say, because I don't mind saying I've written a lot of dissents, part of that is you are signaling to the higher court that you believe that there is a problem that they need to take up. And quite frankly, I've written so many cases at this point in my career. If I don't write my position down, I might forget, where we are in the total scheme of things, what's going on in East Tennessee on an issue versus what's going on in West Tennessee on an issue. And just to make sure that we know, that there's a disagreement or split in the court on an issue, it's important that a dissent be written, and that, judges don't just ignore issues that are bubbling up across the state. So that's one reason, for me at least, that I think it's important to put your position down in a dissent if you can't agree with your colleagues.
I will echo, and then I'll let you move on to your next question. But I want to echo what Judge McMullen just said, because I've had a case where I've been on a panel and I've been the author, and someone has said, I just don't know that I can agree with you. I'm thinking writing dissent, and I'm like, please do. Like, it needs to be signaled to the Supreme Court that there is a differing opinion down here, and they need to take this. We need them to take this and resolve it. So, write a dissent. I've encouraged people to write a dissent in my cases just for that reason.
It is a wonderful feeling when you write a dissent or a separate opinion and you convince one of your colleagues to change their position based on that writing. It's an incredible feeling when that happens as well.
This concludes the first half of my conversation on the history and inner workings of the Court of Criminal Appeals. Part 2 will follow in the next episode of Tennessee Court.